Well, good morning to everyone. It is a pleasure to have the possibility to intervene through a video, considering the fact that I sadly cannot be there in Tirana this time. Of course, I apologize for not being there, but this is it. I couldn't do anything else. I'll go straight to the point of my presentation, and I would like to thank my colleague Petra Sakova for the patience of letting me intervene in this way. Well, exactly 10 years ago, Petra and I were in the US studying under the guidance of Howard Zera at Eastern Mennonite University. And at that time, we were already trying to understand whether restorative justice could or not become a full-fledged paradigm of justice. And after 10 years, we can say that the issue of integrating restorative justice and criminal justice has been widely discussed in the restorative justice debate. It was already a big issue, if you remember, the McCall Valgrave debate and publications, more recent publications like Civilizing Criminal Justice, for instance. Well, it is no doubt that since then, restorative justice has gained a wider attention among doctrine, jurisprudence, and legislators, and it has inspired reforms. Without analyzing in detail the changes that have occurred in each legal system, we can probably say that restorative justice hasn't yet expressed all its reformative potential. It seems, in fact, that there are yet two ongoing risks that both the Czech and the Italian system experience can witness, but which are surely confirmed also within our legal systems. The first risk is that restorative justice remains a sort of Indian reservoir. Restorative justice are placed somewhere at the borderline of the criminal justice system, and both their access and their impact on it lack of relevance, or in case do not help reforming the system as a whole. Restorative justice, and this is the second risk, offers an interesting name for some sort of changing the makeup to old regulatory schemes that yet do not embody restorative justice goals and overall perspective. Under the name of restorative justice, you might in fact find laws, regulatory schemes, whose main aim is, for instance, the eradication of offenders, the deflation of the court's amount of work, depenalization, restitution in a narrow sense, forms of plea bargaining. These interventions incorporate strategies that could respond to different logics. Processual cooperation, controlling the overall expenses of the judiciary system, fostering conducts of cooperation with the judiciary in exchange of reduction of punishments, some generally intended reparations which have not been linked to the real victims of the crime and with the actual harms that crime has created. These, of course, are strategies that might be called restorative, but we are not at all embodying restorative justice's principles and goals. Maybe they do it only partially, but they don't fully do. And sometimes they even derail the whole thing. Well, we can say that probably restorative justice is yet the most remarkable attempt to rethink criminal justice in its conceptual premises, goals and means. And it is no surprise that it involves a deep reframing of criminal justice, which is not an easy task, as criminal justice, as many sectors of law, but particularly penal law, is highly resistant to change. This said, it is also true even from the viewpoint of the Italian system, which has been quite resistant to change more than many other systems. Well, but there have been reforms or projects of reform which cannot be easily labeled as restorative and which yet remain quite heterogeneous, But this doesn't mean that we cannot trace the line of an evolution of all criminal policies that witness a change, or at least a taking a distance from the old punitive approaches to crime, and that some way go towards the direction of restorative justice. Well, this said, the question is still open. It is clear that restorative justice diverges from criminal justice, from traditional criminal justice, in many vital elements. One is the criminal justice is offense and crime-centered, while restorative justice is harm-centered, as we know. One is state and norm-centered, while the other is relationship and person-centered. One has an idea of punishment as retaliation, bad versus bad. The other one promotes forms of re-empowerment, so making things right, as we all know. There is an abstract idea of conflict versus a relational idea of conflict involving stakeholders. One embodies a formalistic abstract idea of punishment versus reparation, which is not formalistic. So restorative justice cannot be introduced in a criminal justice system that remains as it was before. Neither a legal system without a full rethinking can let restorative justice practices enter without being some way put at stake in its foundations. But it is also clear that restorative justice and criminal justice are in a sense requiring a common base. You cannot even talk about victims, offenders, crime, reaction to crime, processes, if these have not yet been legally defined, and if there are no legal instruments for stating and processing them in a way that makes them legally certain, and that grants the protection of fundamental civil rights. Restorative justice needs laws, needs legal procedures, but it interprets them in a different way, which is not in contradiction to law, but certainly is quite different from the idea of law that has been dominant in the last centuries, which is something that has been already debated in many different meetings of the European Forum for Restorative Justice. So this idea that criminal justice is abstract, coercive, statutory, retaliatory, and restorative justice is relational, habilitative, interpersonal, participative, reparative. But as Howard Zerr had already pointed out in the late 2000s, restorative justice and criminal justice can also be viewed within a continuum. On one edge you have a fully restorative justice system, and on the other a residually restorative system. But it is also difficult to put in subsystems whose overall premises are different. So what? How can we try to face the challenge, I'm recalling here Lode Falgrave, of creating a restorative criminal justice system without distorting restorative justice or falling into a dangerous nominalism where restorative is just a name but not a real change? Well, when Petra and I discussed this, we thought that yes, restorative justice has lots to do with participation, with agreements, but the key is reparation. Well, there are also in Italy philosophical elaborations that have sustained the possibility of considering reparation as the main goal of the reaction to crime within the restorative justice literature, but also external to it. I'm thinking of Del Vecchio, Cavalla, Zanuso. I myself try to make a bridge between them. But second point, reparation can be placed as a connective concept between substantive penal law and procedural penal law. Third, reparation implies to focus on harms and is a goal that can be in various forms assumed as a necessary element for the reaction to crime, while participation and agreement are not always feasible. Also, an unrepairable crime could be some way addressed through at least a partially reparative approach to punishment. In any case, the penalistic dogmatic has always been too much focused on shaping crimes on murder, the typical element of an unrepairable crime. Well, this is a very specific and some way not so common type of crime. Another reason why reparation is a key element is that both reparation and harm require to focus on the victim of crime, thereby empowering her role but also providing some borderlines to it. Not always the involvement of victims turns into restorative outcomes, in fact. Well, we also thought about the possibility of legal switches. So we asked ourselves which concepts and legal tools can help a legal system to turn into a restoratively oriented one, leaving possibly the old punitive system on the background, or at least as an extrema ratio, the Latins would say. And here, Petra will probably show a scheme about that. We tried to draw from the proposal of an Italian penalist called Donini, who proposed to introduce the concept of repaired crime. We would like to reframe it into restored crime to enlarge the notion of reparation. Basically, the idea is that if a crime's harm has been partially or fully repaired, this turns to impact the determination of the punishment in terms of either reduction or extinction of the punishment or even of the crime. This could be a legal tool for binding the positive outcome of a restorative process, which could be a victim-offender mediation or a conferencing or a circle. Of course, you might have different possibilities to achieve this result. One of it could be, for instance, a wider use of probation, which suspends or stops the legal process and can divert towards restorative processes. Example, like, as we said, VOC circles whose positive outcome can sort out in an extinction of the punishment or even of the crime. One last thought before I conclude this brief intervention. We also think that we could some way orient towards restorative justice also detention. At the other edge of the system, when all other restorative justice options have resulted impossible or unfeasible or insufficient for many reasons, it is possible to restoratively orient the penal execution and to reframe even detention in order to make it more restorative as possible. So when it's not possible to access alternative measures to incarceration, even detention can be restoratively oriented. And we think that probably issues coming from the APAC experience in Brazil could offer interesting proposals for also European systems as well. Or at least you can offer the possibility of restorative measures at the level of penal executions. We think of reparative dialogues between victims and offenders, for instance, what happens with a Sycamore Tree project, or other forms of restorative measures, or access to measures or activities that can result into forms of reparations to victims, to victim associations, and to the community at large. Well, I thank you for your attention, and once again I would like to apologize for this intervention through a video, and I'm leaving the word to Petra, who will explain something more about what we discussed together, and probably will try to show a sort of scheme that we came up with, and we hope that it's useful for the debate. I thank you very much for your kind attention, and best greetings to all of you from Verona.